Hello, hello, hello. Welcome, everyone. Hello. Welcome to the webinar between crowds and algorithms, decentralized justice in the age of AI, part of, I would say, the celebrations of a new collaboration ongoing between Kleros and CIFILE, the Canadian Institute for International Law Expertise. I am super happy to be here with the president, Dr. Abbas Poorhashemi. How are you, Abbas? Can you see me? Can you hear me? Well, I guess it's going to be fine. There's a bit of a connection issue, but just as Abbas solves the problem, just mentioning that we have started collaborating between Kleros and CIFILE, which is a very well-renowned institute for international legal expertise in Canada. And we have lots of plans moving forward for both of organizations in fostering the adoption of innovation and technology into the world of arbitration. And we organized this little webinar to set a bit the stage of our collaboration in such a way that we can give you an overview of what Kleros does, what CIFILE does, in particular in a context where we are seeing more and more adoption of AI in the solution processes. And this is the goal of this webinar is going to be, speak a bit about that. I'm not sure, Abbas, can you hear me now?
Yes, I can hear you.
Oh, perfect. I was just telling people, how happy we are to start working together. Maybe you can introduce yourself a bit about you, tell the audience about your story, how you got into arbitration, a bit of the history of CIFILE so people can know a bit about the organization. Yeah, please go ahead.
Yeah. Hello, everyone. My name is Abbas Poorhashemi, and I am the president of the Canadian Institute for International Law Expertise, CIFILE. CIFILE working with international lawyers around the world, including arbitrators. And I am also co-founder of Codilex. Codilex is an AI-powered platform for codification and development of international law. So today I will talk about the general introduction to relationship between artificial intelligence and international arbitration.
Cool. So we have here one person coming from the world of technology, like myself, and another person coming from the world of law, like Dr. Abbas. And we will see how these two worlds are now intersecting. I will explain how Kleros is implementing AI currently. Then Abbas is going to tell us a bit about how AI is impacting into the international law field. And then we will have some time for a bit of a chat between us, and then even take some questions by the audience, if that sounds good. Okay, let me then get started with my presentation. I'm going to share my screen, 1 second. Share screen here. Okay, there you go. Can you see it? Good? Yeah, okay. Okay, let's get started. So just a little presentation about what Kleros is for people who don't know it. Kleros started in 2017 in a world where we had more and more international, commerce about services. Imagine a world where more freelancers are working for clients from all over the world. Imagine this woman, she's in France, and she hires this guy from Guatemala to make a video for her company, and then this person makes a video, and there is a dispute about the quality of the product, and then obviously she's not going to go to arbitration for like a $1,000 claim, of course not. This is where, when we started Kleros, we were thinking of this type of use cases where people could make an agreement for the video, for the software, for whatever piece of work was agreed, and then put some money into an escrow, and then have Kleros as an arbitrator to decide the case in case there's a claim. If there's no claim because the quality is good enough, then Alice releases the funds, Bob delivers a product, and all good. But if there is a claim, Kleros will step in as arbitrator while the money is kept in an escrow. And Kleros is going to pick a panel of jurors who are going to analyze the case, each of them independently, and vote on who they think is right. So each of these jurors will analyze the evidence, the product, and the contract, and then vote. And Kleros is built on blockchain technology because of a transparency imperative. The fact that Kleros is built on blockchain gives every party the idea or the certainty that nobody is tampering with the evidence, nobody is tampering with the jury selection process, and that nobody is tampering with the vote counting. So this is a way for enabling transparency and having all the participants trust the system, right? So let's imagine the majority of the jurors vote that Alice is right, so Kleros makes a decision, and then the funds held in escrow are released for Alice, okay? And this ends the case. Well, people always ask, okay, how do you select jurors? And this is one of the big innovations of Kleros, is that at the beginning, so it brought a very important innovation that was the use of a particular token, a cryptographic token that people would have to stake or deposit in order to be eligible as jurors. This is like a lottery ticket. The name actually comes from the ID, bronze ID that ancient Athenians used to select jurors for their popular trials. And Kleros is a bit inspired in how the ancient court system worked in Athens. And so jurors have to stake this token in order to be eligible. And then of all of the people who signal their willingness to work in a particular court, then like 3 are selected to rule on the case. So this is a randomness selection mechanism, and Kleros has many different courts, some of them for e-commerce, others for insurance, and well, others. And people can stake into the court where they have particular expertise, and then there is a random selection mechanism. And another big innovation that Kleros brought into the world of dispute resolution is the idea of game theory. So Kleros is based on the work by this gentleman you see on screen, Thomas Schelling, Nobel Prize in Economics 2005, who invented a concept called focal points that is now known as Schelling points in his honor. And it's about how to incentivize these jurors to make good decisions, make honest decisions, and not to vote randomly, not to be bribed or have any other malicious behavior. Kleros is based on the idea that jurors have an incentive to try to think what the majority of jurors will think and vote in coherency with that. I'm not going to get much into the mechanism because it's more complex and it would take lots of time, but and there's lots of videos of myself actually explaining this on YouTube. But this is one of the key ideas, the use of game theory for dispute resolution and the use of crowdsourcing for selecting the jurors. So this is an idea based on collective intelligence, right? So this very particular mechanism that we developed ends up in a situation where Kleros can become very, very efficient compared to traditional online arbitration methods. Kleros can resolve cases in like a few days sometimes, and at a cost that is maybe sometimes a few $dozen, and with the transparency that brings from the blockchain traceability. And this results in like a system that can be used for lots of use cases where traditional arbitration typically cannot be used because of the high cost and sometimes the international and cross-jurisdictional nature of the cases. Some of the Kleros use cases are from consumer perspective, dispute resolution in e-commerce website like buyers against sellers, disputes between insurance companies and policyholders about who should pay for a car crash and what should be the right settlement amount. This is a very popular use case for Kleros. Then lots of consumer cases in the world of small claims courts, user against the company of telecommunications, water company, electricity company, all those type of utilities claims that typically go to small claims court. But then there is also some use cases that are a bit of a maybe higher value that fall within the world of what we know as arbitration, but not in such a way where arbitration as it exists now would be interested in these cases. In the sense that imagine dispute between two software companies over $100,000, $200,000 between different countries. You typically would not go to arbitration in a traditional setting for such a small amount, if you want, between brackets. It's small, but not that small. So this is where Kleros can be a good solution for resolving these types of cases, international cases, which are not for negligible amounts of money, but still not enough for being interesting for traditional arbitration businesses. So this is another important use case. And then there are other more, if you want, futuristic use cases, but some of them are already happening. For example, esports. Imagine a dispute between two teams in an esports tournament where one accuses the other of cheating, and well, this is between 20 players from 15 different countries, and this is really hard to resolve in a traditional arbitration court. And also think a bit more into the future. You know, you have this metaverse where you more and more often start to work with people, hire people that you don't really know. You don't know their identity. You just know their like avatar. You know their just their well, ID in this social network. So you have no way to make a claim against the person that you don't know the identity. So this is a more and more common use case that is going to come more into the future. So since the very early days of Kleros, we had theses about how the world is going to evolve in dispute resolution. We thought that for simpler cases, more objective cases and low value, this could be automated through an AI mechanism. For a bit more complex cases where you have to evaluate the intent of agents doing a contract, or you have to evaluate some emotional situation. So this is where we think that decentralized justice mechanisms with humans as jurors will be more prevalent. And then for like higher value, more complex cases that require ethical judgment or legal reasoning, this is going to be resolved still by more traditional dispute resolution mechanisms, like a courts and arbitration as it exists currently. Let me tell you a bit also how we have been working empirically about this combination between AI and decentralized justice. So one of the use cases is using AI as a kind of advocate or lawyer for users. We have a partnership with a company called Lemon it's a fintech from Argentina, and they have lots of, as fintech companies do, lots of disputes and claims coming from unrecognized credit card transactions, errors in internal processes, and there is claims. The user typically goes to customer service, and customer service sometimes says that the user is not going to be reimbursed as requested. And what happens in those cases typically is that the user only solution is just to go to small claims court, and that's it. What people do typically is they sometimes, most of the time, they don't go to small claims court. They just stop using the company. They move to the competition, and then what they do is, if they are very frustrated, they just go to Twitter and say, these guys from this company are scammers, don't buy from them. So there is like a reputational problem, a reputational situation that affects the company. So this is how we designed the process for dispute resolution with this company called Lemon. The user goes to the company, there's an evaluation by customer service, it decides against the user, and then instead of finishing there, what happens is that there is another instance where people can, the company offers the customer going to Kleros for a neutral decision about the case. And Kleros jury is picked, and the jury analyzes the case and makes a decision. And if the customer wins, the company just accepts the ruling and reimburses the customer for what the customer wants or is asking. And if the customer loses, it can still go to small claims court without losing any access to justice possibility. So when we started this pilot, we found that many of the customers claims were like not very high quality because these people were fintech users. They were not lawyers. They didn't have the knowledge or the experience to write a clear complaint. So what happened is that the company decision, the company answer was done by a team of lawyers. So there was an imbalance between the company and the user, which kind of biased the situation in favor of the company. So we started using ChatGPT basically to ask with the prompt, a very simple prompt asking, okay, you need to take this claim and make it clearer, make it longer, and increase the quality. And ChatGPT made the new claim, and this balanced the situation between the user and the company. And this, you could see how the amount of cases won by customer went up because they had like a better situation. I mean, a better defense. So this was basically using ChatGPT or AI as a lawyer, as an advocate for the user, helping him make a better decision, a better claim processing. And the results are spectacular. So the cases are resolved in only 4 days against more than 13 traditional processes. The cost is just a few $dozen, and the transparency is important. The user perceives that the process is fair. And the most important metric here is that we go from 80% of users who abandon the service after having the problem to 90% of the users who lose their case against the company, and they still remain as customers, and they are happy with the process because they were given like their day in court, if you want. So this is a way for you to see how AI can be part of the process of dispute resolution as a kind of advocate for a user, helping the user to improve the way in which it presents the claim. And another way, and this is what most people are interested actually in, is can we use AI as judges? In a very old interview on TV in the very early days of Kleros in 2016, I was interviewed by Max Kaiser, who is a guy who had a program in the UK television, and I was just starting. And I was in this video. He was asking me about AI and if you could use AI for dispute resolution, and I was telling him, yeah, of course, in the future we will have a claim of AI suing another AI, and this could go to a panel of AIs, and this could be done. All of this could happen within a virtual reality world, in the metaverse. So this was super weird back then, but it kind of is not very weird now that we are starting to have like AI agents starting to do lots of activities. And one of the questions that people ask themselves is, when we use AI for dispute resolution, will we use like one algorithm or many? Because we have explored this, and we have seen that it depends on what AI you use. The decision that you will get can be like different. And so we tested this with football games. So we just did a kind of testing where we had 3 AIs evaluate a football play that was controversial because of some reason, and see if the different models actually agreed on the decision, right? So one of the models was ChatGPT, another was Gemini, and another one was Claude. And then one of the plays that we put forward is one very famous disallowed goal by a player called Frank Lampard from England in South Africa 2010. And then we wanted to see if we were to use this as like a VAR system, so what would it result? So should this goal be considered a valid goal or not? So we put this for the AIs to see the video, and each of them had to decide whether it was a goal or not. And then here you can see that it's very clearly it's a goal. And so the agents, all of them agreed that it was actually a goal, and also they gave a justification. When jurors vote in Kleros, they also justify their decision, and this is what juror 1 said and how it was justified, juror 2, and then juror 3. Okay, so the three of them, all of them agreed, so all good in this case. But then we put another case that was collision between the German goalkeeper Neuer and Higuain in the 2014 World Cup final, and we asked if this was or not a foul. And here you can see the collision, and this is a bit more, I mean, I guess controversial, a bit harder to define, and it's, I don't know, depends on where you're from, and if you're German or Argentinian, might have a different opinion. But let's see what the AIs said about this. So here we saw that there was disagreement in the decisions because 2 AIs voted that it was not a foul, and 1 model voted that it actually was a foul. And each of them gave justifications. The number 1 said it was not, there was not an intent to foul, so it was okay. The second one said it was a foul, and what is interesting is that it provided like a precedent, like here it says similar challenges in past tournaments have resulted in penalties and red cards, and it shows it brought a collision from 1982 World Cup. That was super interesting as the use of precedents for decision making. And the third one said it was a foul. Okay, so this is really interesting because even in something as simple as football and like these football plays, if you can have AIs disagreeing on the outcome, what could happen in like a more complex situation of a real dispute, typically of arbitration, right? So we are now starting to work with this type of use case of using different AIs for dispute resolution in IP claims. For example, a situation where there is a copy of an original and people want to know if this is confusing to customers, if this is a copyright infringement or not. So we developed a tool called Mirrorfall, where you can upload an image and then the copy, and then this will call for different agents, different models to analyze whether there is actually or not an infringement, and it gives you a percentage of infringement, you know, of similarity. And if the case is kind of a bit not clear cut, it will escalate into a human panel done in Kleros. So here you can see how there is a first instance done by AI, and this AI is done by different agents. So it's an AI panel of jurors, and then this escalates to another panel, but this time of humans. Okay. So in the future, what we will have is that disputes will have AI in different stages. First, it will help parties improve their depositions and their like claims processing. It will be used to anonymize evidence where it's appropriate. There's probably going to be like a first instance made by different models that will make a first decision on the case. If this case is appealed, it might be appealed to a decentralized justice court with humans. And this is how AI is starting to become integrated with decentralized justice systems. And at the end of the day, this could actually go to a panel of traditional arbitration. So just to finish now, the future of arbitration, as we see that Kleros is going to be a division of labor. So for more like simpler cases and more objective cases and low value automation, cases more in the middle, panel of jurors, human, more complex cases, traditional arbitration. There's going to be a collaboration between humans and AI, for example, in AIs advocating for humans, and then a sequence of cases where a decision done by AI can be appealed to a panel of humans. And we are super happy with the opportunity to start exploring this future with CIFILE, and it's great to be able to interact with Abbas and see in which parts of more traditional processes of arbitration we can implement these tools. Also, just 2 more things. We actually published a book chapter. We wrote a a chapter that is going to be published very soon with William and our head of research, and Rob, who is member of the Kleros board and the dispute resolution professional who works in Abu Dhabi, about these ideas that I presented here about how decentralized justice interact AI. Is going to be published very soon at Walters Kluwer. It's a full chapter with all of our research about this topic. And final thing, if you are interested in working on this type of topics, there is currently open symposiums, call for papers at the Stanford Journal of Blockchain Law and Policy, where you can submit your research about Kleros and AI, and you can get the opportunity to be published at a very, very good place, be read by really smart people. So it's a great opportunity. If you are interested in these topics, you can write about this. And if you want to contact me, please, you can do it here. And so thank you very much for your time. And yeah, I will stop here. Thank you. Hey, Abbas.
Thank you for your excellent presentation and relationship between Kleros and international law and developing international law for our future. Thank you all for being here today, and it's a pleasure and honor to speak with you. As you know, international arbitration today faces a real and serious paradox. On one hand, arbitration has never been more important. Across the world, state investors and companies rely on it every day. They choose arbitration because it is neutral. They choose it because it works nationally and globally. They choose it because it offers expertise and flexibility. For resolving complex and high-stake international dispute, arbitration has become the preferred mechanism at national and international level, both. And yet, at the very same time, arbitration is under growing criticism. People increasingly question how expensive it has become. They question why cases take so long. They question why similar cases sometimes lead to very different outcomes. And they question whether arbitration truly delivers fairness and balance between parties. So as arbitration handles more cases and large and more complex cases, the pressure continues to grow. Confidence in its efficiency, its coherence, and its legitimacy is on real strain. So, practice. I saw many times in CIFILE that our arbitrators and lawyers talk about the problems and challenge facing in their practice. So, you know, costs keep rising year after year. Cases that were once expected to finish in a reasonable time now last several years. Tribunals and counsel face mountains of documents, far more than any individual can realistically read or fully observe. Different fact very similar, and many parties worry about transparency, whether both sides truly have an equal opportunity to present their case. These are not small or technical inconveniences. They are serious warning signs. They show us that international arbitration has grown enormously in size and complexity, but its internal working structures have not evolved at the same pace. Not see AI as an external force that threatens arbitration or seeks to replace it. AI is not an enemy of arbitration, and it is not a magic solution either. So AI is better understood as an internal process, both in international law, in arbitration, and other of law. So it is a tool that helps arbitration manage the challenges it has created for itself. Today, my main argument is simple. Artificial intelligence offers a practical and step-by-step path toward what I can call the development of international arbitration. Turning arbitration into an automated process. It is about carefully and technically grounded improvements. Improvements that help arbitration return to its core strengths. What are the core strengths of arbitration? Is clear reasoning, real fairness, predictability, and trust. So to understand why AI matters, we must briefly look at the main problems and challenges facing arbitration today. The first problem is looks very similar to long and complex court litigation. Parties submit extremely long written pleadings. They produce tens of thousands of documents. They rely on multiple experts and repeated round of submission. All of this takes time. All of this costs a great deal of money. As a result, arbitration has become slower and more expensive than many parties ever expected. More importantly, this procedural overload favors with greater financial and technical resources. Large corporations and wealthy states can afford aggressive strategies, large legal teams, and extensive expert evidence. On the other hand, smaller companies and developing countries often struggle to keep up. This weakens the fundamental idea that arbitration should offer procedural equality and balance. The second problem here is inconsistency in decisions. This issue is particularly visible in investment arbitration. Similar treaty provisions are interpreted in different ways by different tribunals. Sometimes nearly identical facts lead to very different legal conclusions. This creates uncertainty in international arbitration or national arbitration procedure. Investors cannot easily predict outcomes and output of the arbitration. States find it harder to design stable regulatory policies, and the overall credibility of the system suffers. A dispute resolution system cannot function properly without a reasonable level of predictability, because when we try arbitration, each party, they should have a minimum of predictability of the result that they can have. So the third problem here is concern human limits. Even the most experienced and ethical arbitrators are human. They face heavy caseloads. They work under time pressure. They must process vast amount of information. And like all human decision makers, they are affected by unconscious bias that Dr. Federico mentioned earlier about the unconscious bias. So as you know, these are not personal failures. They are natural limit of human cognition, especially in complex, high-stake disputes. Now, intelligence does not decide disputes. International arbitration remains a fundamentally human process. It requires judgment, it requires fairness, it requires cultural understanding and sensitivity, and it requires discretion. These elements plays a supportive role. AI helps arbitration manage information. It helps them organize large volume of documents. It helps them identify patterns and inconsistencies. It helps them identify or locate relevant procedural more efficiently, and it helps them reflect more carefully on their reasoning, on the submission, or finally on the award. In a simple term, AI does not replace human judgment, but it strengthens human judgment. AI also helps improve consistency without turning arbitration into a rigid system. It does not force tribunals to follow previous decisions. It does not impose a system of strict precedent. Instead, it provides better information. It shows how similar issues have been treated in the past. It highlights where tribunals are converging and where they are diverging. This creates great coherence while preserving arbitral independence. So we can call this soft harmonization. Another major benefit of AI is efficiency and fairness. AI makes arbitration faster and less expensive by automating repetitive and time-consuming tasks. It helps sort documents. It translates materials quickly. It summarizes long texts. It reduces unnecessary duplications. So this saves time and reduces cost. Even more importantly, AI helps level the playing field. Smaller parties gain access to powerful analytical tools. Developing states no longer face such a severe information disadvantage. The gap in expertise and experience becomes smaller. This strengthens equality of art, improves access to justice. Of course, none of this should happen without safeguard. So we should have some safeguard to applying AI in arbitration. So AI must be governed, not simply adopted. Party must know when AI is being used. They must be able to question and challenge its outputs. Confidentiality and data protection must be strictly respected from the beginning until the end of the process, arbitration process. So above all, human judgment must remain in control. AI should always be trusted assistant and not a decision maker. We never use AI as a decision maker. We use it as a support and as a help to judgment and procedural justice. So let me conclude. International arbitration is highly sophisticated, but it is under structural strain. Artificial intelligence is not a shortcut to justice. It is a disciplining architecture. So used reasonably, helps arbitration become more consistent, more efficient, and more fair, while protecting arbitral decision. In this sense, AI is not just a future arbitration. It is how arbitration presentation. Dr. Federico.
Thank you, Abbas, for this extraordinary presentation. Yeah, these very thoughtful ideas. We have a big part of our audience is they come. Some of them are innovation lawyers. Others come from the field of technology. So they are not all of them are very much familiar with the evolution of the arbitration industry. You mentioned a bit, but I want you to explain a bit more about this topic. In the 1950s, when the New York Convention was signed, what was in the mind of the people who were working at that moment in terms of bringing flexibility in how disputes would be resolved, and how this flexibility of procedure was lost a bit in the road as the arbitration started to become more like a court process. I mean, can you explain a bit about this evolution? You mentioned in your presentation, but I would like you to explain a bit more about that. You're mute, Abbas. Are you there? Okay, I will. While we see if Abbas can come back, we have some questions or more like comments from the audience. So one of them is from Raimundo Vives Lopez. Is a litigation and arbitration attorney, and he says, I am not so sure that AI financed by institutional investors and big companies as a judge or arbitrator for simple or low quantum disputes, while traditional courts financed by general taxes of the nation paid by ordinary citizens are those who have simple low quantum disputes are reserved for the most complex disputes. I don't know if this is fair or equitable. So let me a bit expand on what we see at Kleros and how we envision this, and how from our experience also. So courts are like they have lots of backlog. They have a lot of cases. They cannot resolve them fast enough, and this is where people. I mean, they are having. Are you back there? Yeah. Just commenting this, and then we go back to the question. So what we see is that they are typically open to try to use new things, and this is why in the past few years there's been like a bit of a revival of alternative dispute resolution, technologies, but so many times there is like institutional barriers in the sense of compliance requirements about digital signature. Sometimes it's like the world of dispute resolution and technology moves at a very different speed than the world of governments. So what happens in this type of cases is that most of the disputes tend to be solved by what I call sometimes, the shadow legal system. What do I call the shadow legal system is think, for example, Facebook. You have a dispute solution system which is internal at Facebook, and they deal with lots of claims about, for example, IP infringement of like a photo. They deal with like user abusing other, verbal abuse, a lot of things. So in the traditional world, this type of disputes would go to libel court or whatever. But in this world of today, they kind of go to a private system that is controlled by Facebook or by Twitter or by whatever big tech company that handle the process. And this decision is done without any care for the due process, because this is done by a moderator appointed by the company, following rules by the company, and this is an entirely private process. You don't have a way to appeal. It's very hard. I mean, in theory, you can still go to a court against Facebook if you got banned from Facebook or Instagram, and because of a reason you find unfair. I mean, in some jurisdictions you can go to court and try to have this reverted. I mean, good luck with that, because it's really, really hard. So what happens is that the rights of people end up being controlled by these big companies without a due process situation. I don't want to put this into like a conspirative focus, because it's not. I mean, these companies are trying to give the best service they can, and they have to deal with huge and millions of disputes. I remember, for example, eBay had 60 million disputes a year at some point. So they try to do the best that they can, but it's their business is not resolving disputes. Their business is having users interact, having users use the platform. So what happens is that a big part, because of the problems of state court systems in resolving these small claims, the process becomes privatized within big tech companies that do the solution as part of their service. This is what happens, and it's typically not for the big arbitration. I mean, not for high-value cases, because most of these are small-value interactions. Some of them maybe are not, but the point stands that rights of users are kind of a bit at mercy of, a private decision-making process in a company. Yeah, Abbas, do you want to comment something about this?
Good. Yeah, it's perfect, your presentation. But I want to add something. As you know, the AI, because we have some impression about AI. AI is not only the chat box or chatbot, or, for example, the algorithm from the social media, because normally people think about AI, they automatically think about ChatGPT or chatbox on the system. But really, the AI is multi-layered, technical. We need technical infrastructures embedded across the bilateral lifestyle, and in arbitration, for example, from case intake and document production to hearings, deliberation, and even award drafting. We can use AI, but we should have the safeguard to use AI on the arbitration and the legal system mechanism. So we need two different things. One, infrastructures like Kleros, like Codilex, and like other platforms that we have in AI and law. And another side is the ethical usage of AI. So when we see both sides, that we can help for future international law and arbitration both.
Expand a bit on this idea of what do we call ethical use of AI? What are the conditions for AI use to be ethical, and what does like a breach of ethics looks like in the AI and arbitration world?
The first of all, we should keep as a lawyer and arbitrator, we should keep the confidentiality. And as you know, some AI mechanism, they can use the information from the lawyer or arbitrator to develop the infrastructure, AI infrastructure. So when we use the AI, we should have the confidentiality. We keep the confidentiality, and privacy is very important for lawyer. And we cannot use AI as a shortcut to justice. We should use AI as a support to the decision maker and to support to avoid and to support to identification of argument of in legal procedure. So AI is not directly used as a judgment. That is very important issue that we should have for confidentiality to data protection for our clients.
I always like to mention this scenario where, we totally agree that AI should not be used as a final decision-making mechanism. There should be always a possibility of appealing to a human panel or human person making the final decision. However, and this is what we see in real world scenarios, what will tend to happen is the following. And there was this famous case in the UK. They were using this AI tool called HART, for predicting the likelihood of reoffending of prisoners that were arrested. And this used to give like a percentage of reoffending probability. And then if the percentage was above X percent, the person was detained. If it was below, it was released. So the thing is that what they found is that there was a bias, that the AI was it was unfairly punishing people from poor neighborhoods, and so giving them a higher risk profile than what they should have, causing them to stay in jail when they should, not be in jail, basically. And but the question is, let's say you are the person that will review the AI decision. So the AI gives you okay, there is a 90% of probability that this person will reoffend. And you think maybe not. Maybe this person decided to reform herself. You may have an interview. And would you take the risk of releasing this person and contradicting the AI? And then what happens if it does reoffend and commits a crime? So what do you think of this type of scenarios where in theory there is a person making the final decision, but in practice, no?
Yeah, AI should not be decide the judgment, because judgment as a judge or as a lawyer, as an arbitrator, is a human activity. So we cannot. So AI does not decide cases. It supports. It supports human decision maker. It's helped me as a judge or arbitrator or even as a lawyer. The AI helped me to find the better decision or just or balance. But finally, at the end of the day, it's the lawyer or judge or arbitrator should be decide, not AI. That's the difference, because AI at the end of the day provides information, or for example, it show us how similar cases issue were handled before. For example, the Harvard Tribunal tends to agree or whether they take different approaches. So it's helped us to, for example, to require document or, for example, avoid repetitive information, or that's the AI help a lawyer. But at the end of the day, it requires judgment and balance and weighting of competition values as a good faith and or public policy. That's not on the scope of the AI. That's the human activity.
We have a question here about this topic about public policy. So from Juan Camilo Macías Gómez, is a PhD candidate in international economic law at Paris Panthéon-Assas University, a very good university, by the way. And he says, there is an issue of how to enforce the decisions. I know that we have the Mexico decision where the court concluded that the Kleros decision would be enforced in Mexico. However, there is an issue of international public policy. How can Kleros jurors or one AI system take into consideration the notion of international public policy while making decisions? Let me just comment on the Mexico decision. It was very famous case that was resolved in Kleros 2021, where there was a lawyer from Mexico, an arbitration lawyer, that wanted to test whether Kleros could be acceptable as a kind of arbitration method in Mexico law. So he made arbitration clause in a contract of a landlord and a tenant, and then in this arbitration clause he put that if there is a dispute, it should go to Kleros for resolving, okay, for resolution, like a traditional clause of arbitration. So there was a dispute where the landlord accuses the tenant of not paying rent. So the case is sent to Kleros. The case is loaded into Kleros. The jurors make a decision, and then they decide in favor of the landlord because of the tenant had not paid the rent in time. And this arbitration lawyer sent this case, the decision, to the judge in Guadalajara, in Mexico, and this was accepted as a valid decision because, there was a clause of arbitration, and there was a process following that clause that made a decision, and so the judge saw no objection to this being enforced because it was it was as it was agreed by parties. So it was like a big thing because it was the first, ever, if you want, blockchain arbitration decision that was kind of enforced in the traditional court world. So there was there is a very good article by Maxime Chevalier, a lawyer from France, who did lots of work in Mexico, where he explains how this is type of bridging the arbitral order with the blockchain legal order. So strongly recommend. But what is the answer about the international public policy part of the question that you might address better than me?
Yes. At the national and international level, we have two different public policies. It depends on the cultural, political, economical situation of the scope. For example, if we are talking about public policy in the country, it depends of all aspects, multiple aspects of cultural, political, economic situation of that country. So AI in this context can help us to better decide when we are talking about applying public policy in one case as a judge or as an arbitrator. So it is not uniform or, for example, uniform decision for all of the case. As you know, the case by case is different. But here, they help us to carefully humanize the decision. That is very important because in any decision, at the end of the day, the judge as a human should decide, or arbitrator as a human should decide. So when we are talking to public policy in global level, because we have a lot of countries around the world, so the public policy should be according to their national interest, national public order, and etc. So here, AI can help us for legal reasoning, but it should not be automated. We cannot the award or judgment should not be automated, but it helps us to gather information, to receive the best information that we have to any cases.
What would you say if some of the people who are doing at the forefront of AI, for example, like Dario Amodei from Anthropic, he says that very soon AI will be able to do almost everything that humans do. We can call it AGI if you want, or we can call it advanced, whatever, so you don't get into that debate. But at some point, if AI can actually do everything that we do you think humans will start accepting the AI decisions as final, or being a human is still a different thing? I asked this question myself, honestly.
From the COVID-19, a lot of institutions they are trying to use AI, not directly but indirectly. Even now, some courts and some international system, court system litigations. They are trying to use AI, but as as a support to decision, not a final decision. And as you know, when personally I use AI for my case, this is some risk that should be solved maybe in future. One of the risk is to bias. As you know, when the system is based on algorithm and LMP and special language to train AI, and sometimes when I ask one question, one identical question from different application that we have, open access applications, they give me different answers based on the country that created the AI, based on the culture that created AI. So they give me different answers. So the first risk for legal matters is related to bias. Secondly is transparency. They give not they give didn't give me the base and the logic that should have the result of the question, because they give me the final answer, but they didn't give me the solution and how it's reached to that response. Another risk for lawyer is due process. Due process is very important, even for arbitration, for judgment, for legal professionals, both. Another risk is cybersecurity. Cybersecurity also is very important for a case, because you are, as a lawyer, you have the many high rank information and confidential information from the clients, and if somebody can rob all your information as a cyber security. And finally, enforcement, and that the question that was all that need or caution when we use AI in legal professionals.
There is, a question I ask myself, if AI can solve a case in like a few minutes or seconds. In what sense this it becomes like legitimate for parties? Because parties there is like also a ceremonial aspect to dispute resolution where you expect someone to spend time in your case, you being able to make the position, someone thinking about you, empathizing with you. What AI solving this in 2 minutes? Could this be seen as an actual resolution, or this is like a summary? I don't know. This is a very human thing that I don't know AI can replicate easily. What do you think of that?
Sometimes I think that AI for us is like an agent or your secretary, but he or she is very fast. She give you or he give you all information that is available on the internet, so they can process all information. For example, a human should search in different sources, for example, like UN database, ICC database, ICJ database. But now, if you train or you give the good prompt to the AI, they can find the best question, the best response from that database. Instead, you should see each sources, verify each sources, and search on multiple resource, but AI can do it very fast. So this is a very interesting, but it can summarize, it can gather all information. But for me, as personal, when I use AI, I verify all information. In this stage of AI that we are talking today, in February 2026, AI is not trustable. You should, as a lawyer or arbitrator, you should verify all information. AI help me to find my response, but it is not trusted. You should verify, because I know that AI is not trained yet. Many applications and try to train AI to have a appropriate response to the question, to legal questions, but it is not trusted yet. We should work on it. We should train AI for the future development of legal professionals.
And how legal institutions, traditional institutions like CIFILE, are adapting to this new world of dispute resolution? I mean, what is how do they adapt to a world where like the courtroom or the hearing room is like a piece of code? What is the role in this new world?
Yeah, actually, we don't suggest all of the lawyers that they use to AI, especially open access of AI, because the information is not accurate yet. But we, as a preventive, we give them some advice that they should have the transparency, or they should keep the confidentiality, especially data protection is very important for lawyer. But in our institute, we are not achieved yet to have a one policy to use AI for all legal professionals, including arbitrators. So until now, because we are in Codilex, for example, we are working to train AI to limit or to decrease this risk, but we need to work. We need to have some time to finish the project.
We have a question here from Daniela Gandorfer, Innovation Strategies, Web3 AI and Digital Governance. Thank you for your interesting insight. I agree with Kleros' potential to democratize access to dispute resolution. Thinking a step further, what do you see as your biggest competitors, and imagining it becoming a market? How does the fact that we have competing companies influence how disputes are resolved? Competition as a market mechanism in comparison to the traditional legal system. I think, I mean, this question I think more for me. I think that competition exists in the legal world as in any issue of life, in the field of life. Clearly, there is competition between arbitration centers. So arbitration centers try to attract businesses from disputes from the different companies, by offering a number of value propositions, including a roster of arbitrators that are more trusted, transparency in the process, and lots of different things. I can imagine that these institutions might also adapt by starting to implement new technologies to offer system which is faster than what Abbas explained before, that takes a long time to resolve a dispute. In the case of Kleros, Kleros is typically, and this is how we see it, is Kleros is not going to replace arbitration. It's not going to. You will not use Kleros to resolve like a $1 billion dispute between oil companies or construction, companies. This is going to still be done by traditional arbitration processes. But I can totally imagine, for example, a court or arbitration center starting to address a bit of a lower value disputes, not consumer, like lower value as like $200 as we do with other companies like in fintech, for example. But for example, think of $100,000 dispute. So between a software company from one country and a company from another, and this is not like this is not nothing. It's not like it's not peanuts. It's a big amount of money. But you will not go to an arbitration process, in a traditional arbitration center, typically for this amount of money. So there is like a market segment there that goes maybe, I don't know, from 10,000 to 1 million, just to ballpark, where you have disputes in high volume because of the economy becoming more global, more interactions between companies, etc., digital economy and all that, and you don't have a decision-making process that is seen as neutral, fair, that can operate at that low cost. So it makes sense to resolve those disputes. So you could see in that case, like Kleros becoming like a market process, I mean, a market mechanism, I mean, or a market solution to a problem that exists currently, but that was not properly solved yet by existing offerings. So this is how you can see Kleros being part of this arbitration landscape without actually competing with arbitration centers. I think that what I imagine, if you ask me, is that arbitration centers will have like a lower or middle value kind of offering for like smaller companies and smaller disputes, where there's going to be like a process that is a bit hybrid between Kleros and traditional decision making from that center. We are, I mean, currently exploring this. I mean, I cannot say, but we are working with arbitration centers to see how this process would work and what would be the value proposition and how to implement it in a way that is like compliant with the rules. So this is how we imagine this working. And also, don't forget that arbitration itself was also born, as a market solution for a world 1950s. I mean, arbitration is very old. It's from the Middle Ages and before antiquity. But the modern idea of arbitration, the New York Convention, comes in the 1950s in a world where we have more international trade, the post-war order, and we have more multinational corporations investing in different countries, trading with different countries. And in this ecosystem, in this new world, they have more disputes, and this is and they figure out that this is hard to solve with national courts because, different things because of jurisdictional problems, etc. And international arbitration, I mean, kind of came from a market solution into try to solve that problem in the context of giving also companies more flexibility on how to resolve the cases. And this brings me back to the first question about how arbitration came from like a idea of having a flexible process for dispute resolution to a process that now looks more like a traditional court process with traditional what arbitration wanted to a bit like not be, it has in the end become. I don't know, Abbas, if you want to react to this, because you mentioned this in your presentation.
Yeah, as you mentioned, the purpose of arbitration is saving time and cost, because it's flexible and both parties are agreed to have a timely and costly process. So AI in this context does not impose uniformity, because it promotes only coherence in practical and flexible way. That is the purpose of arbitrations, the relationship with the AI. It helps our participation make better decision. I mean, they help arbitrators to make better decisions while preserving the independence that give arbitrator in values, or value I mentioned before in my presentation.
Okay, we're running out of time. We have another question, and I will do this last one. I would like to thank you. This comes from Ventislav Asparuhov. I would like to thank for the choice of topic. Which types of disputes do you believe are most suitable for decentralized justice today? And what are other categories of disputes that should remain firmly within traditional judicial or arbitral structures? I think I already answered to this. Like lower value claims within national boundaries, consumer claims of really low value. In international settings, it can go a bit up, but it's going to be measured in the thousands or sometimes hundreds of thousands. It's not going to be measured in the millions for disputes happening in the millions. I mean, I think you should still go to an arbitrator working into a traditional setting. This arbitrator for sure is going to be assisted by tools of AI, as Abbas mentioned, and this is perfect because it will help this person make a decision which is faster, cheaper, and all that, but it's still going to be done with a procedure a bit more similar to well, what it looks like today. There's a lot of different industries. I mean, if you want, I already mentioned this in my presentation, but esports, you have disputes between gaming people from different teams in esports tournaments. You have like a metaverse disputes in social networks, lots of activities that are a bit by their like nature, like transnational, and that they produce conflicts that are not hugely, not of big value as investment or big trade. These are potentially being good for Kleros. Okay, I think we are running out of time. I don't know, Abbas, if you want to say some final words. Yeah, please go ahead.
Thank you so much for your presentation. Thank you all to be here, and that's our pleasure to work with you. And I'm happy that we have the collaboration between CIFILE and Kleros.
Thank you very much, everyone. I'm also very happy with this, and you will hear from us in the coming weeks and about new initiatives that we are going to start doing together. So thank you very much for coming. Thank you, Abbas, for participating in this webinar. And I guess see you very soon. Bye-bye.
Thank you so much. Bye-bye.